Stephen Muir for Mr. Anderton. We have a disparate verdict.
Raise your right hand, sir. Promise to testimony about to give the cause now and guarantee to be the truth, the whole truth, nothing but the truth, so help you God.
I do.
Judge, I do also have a written impact statement here for you that's also been provided to the defense counsel. Judge, on December 1st, 2009, the Boxborough Minutemen, a non-profit group that raises money and donates to various causes in the town of Boxborough, recently elected a new treasurer. They were going through financial records and realized that their account seemed very, very low, the balance seemed very low. They then looked back at the statements for the previous 3 years and noticed the same pattern. They then approached the former treasurer of the Boxborough Minutemen, which is the defendant before you today, Mr. Anderton. They approached them, and Mr. Anderton admitted to embezzling money over the last 3 years from the Boxborough Minutemen. The total amount of money that was embezzled was $66,343, which the defendant has paid back to the state. He has paid it back to the Boxborough Minutemen. He did admit to this crime. He did admit that he did do this to the Boxborough Minutemen, and those are essentially the facts.
Particularly complicated case. All right, you're looking for 2 years of probation with this guilty plea?
Yes, Judge. The Commonwealth understands the defendant has no record. The Commonwealth also understands the circumstances the defendant was in. However, due to the amount of money, Your Honor, over $65,000, the fact that this happened over a period of 3 years, the defendant being in the position of a non-profit group as a treasurer, that responsibility, the Commonwealth believes that guilty 2 years probation is appropriate.
Well, I suspect I'll have to take some advisement because a lot here is
And I have a bit more, Your Honor.
What's that?
I do have a bit more, if I may approach.
Yeah, I'll hear you. I'll probably just take a recess and Your Honor, allow that to read everything. I don't want to keep you waiting all day on this thing.
I understand, Your Honor.
Read everything you submitted. What should you tell me? What happened?
The facts are not in dispute, Your Honor. This is an individual who had a position of leadership and was in line to lead the group. He was in a position of trust and authority, and he had the means, without supervision, to do what he did. And because of his personal financial woes and hardship, he succumbed. He did it for his family. He did it to support his wife and children. And as a consequence of having done that, he's here before you today. And although he's made admission, contrition, and restitution, we have to come up with a resolution of this particular matter. We are asking for a continuous without a finding with a probationary period. We understand there will be fines and assessments based upon the nature of the individual and what he has personally gone through, loss of house, loss of family, loss of dignity. Fortunately, he's still gainfully employed. A guilty finding.
Where does he work?
Yes, he works.
Where is that?
He works in high-tech, locally, high-tech sales. A conviction on a serious misdemeanor of felony would have horrible repercussions to him with regard to making ends meet in the future. Mr. Anderson was born in the United Kingdom. Came here as a working adult. I had a lucrative position, which ended because of the failure of the company rather soon after he came over. He's now a naturalized citizen, has been for a number of years. He then invested in a company that he founded that, due to the economy back a couple of years ago, also went belly up. He had no safety net. At the same time, both he and his wife were also from England, had personal family tragedies with regard to the parents' care, their parents being institutionalized and their parents dying without much, if anything, in the way of any inheritance, so the cost of going back and forth really impacted the family badly. To make ends meet, Mr. Anderton worked as a limo driver, worked in telephone sales, worked as an IT consultant, sort of type wages, delivered newspapers, did whatever he had to do to try to make ends meet. Circumstances were such that he couldn't. Now, we don't offer any excuses, and I'm not going to do this in the way of background, but there's no drugs involved, there's no drinking involved, there's no gambling involved, there's no whoring involved. It's just an unfortunate circumstance. It's almost Dickensian. And here we are deciding what are we going to do with this individual. And I understand that a quaff might be the most lenient type of disposition, but it also may be the most just and fair under the circumstances. I had a detailed conversation early on with John Verner, ADA out of Middlesex and Woburn, because the Commonwealth obviously had the choice of filing this as an indictment in the Superior Court and taking it that way. Mr. Verner, ADA Verner, decided not to do that, and I passed forward the letter with regard to that. Arraignment in this case was on the 17th of February. Prior to that, on the 16th of February, a note was signed, the mortgage was given as collateral security. Mr. Anderton has always cooperated fully. I brought him into the Boxborough police. We cooperated fully at that time. Again, he didn't seek to hide, he didn't seek to do anything but cooperate fully to bring the facts of the case forward without excuse, and then directly to the group, he expressed his remorse, his embarrassment, and his guilt, and then made restitution. There is a letter in front of you, or a notation from the group, the Boxborough Minutemen, and it's a second version. As your honor reads through it, you'll notice that it was written at a time when the organization probably had its most pain. Restitution had not yet been made. This was early on, probably in the late winter, early spring of this year. And since that time, they have received the money back. I understand how hurt the group may have been. I understand the sleepless nights and the anxiety that they may have gone through in order to meet or worry about meeting their obligations. The defendant has gone through the same thing. By his own hand, admittedly, but by the same token, by allowing him a quaff, doesn't mean he's out of this scot-free. He's made restitution. He's had a personal loss of dignity. His marriage is probably irreconcilably broken. He fortunately maintains good relationships with both sons. The family is from a nice house in Boxborough to a marital rental in Maynard. He's living apart in an apartment in Anderton. This man has not escaped scot-free. The question becomes, what's just under the circumstances? How do we resolve the case? Especially in consideration of the fact that I've been doing this a number of years, Ron, and it's very rare that you see someone ab initio, from the beginning, come forward and admit what he's done and try to rectify it. I'm not saying that that's exemplary behavior, but it's exemplary behavior for a defendant under the circumstances to admit what he's done, to express his regret and remorse, and to exhibit the fact that his rehabilitation, I mean, he understands the nature and consequence of his act. The question becomes, how should we punish him? And I say to you, Your Honor, that a guilty finding is much more fair than continuing to a finding, which I think under the circumstances is fair in this particular case. Thank you for your consideration.
On the one hand, you said it was what is in his favor is the fact that he has no prior record. He was remorseful and cooperative from the very beginning and he made for restitution. On the other hand, this was constantly occurring for 3 years, which was a one-time thing when he just had a moment of desperation, financial desperation, and needed money, and he just did something that didn't happen. This was deliberate conduct over the course of 2 years. There is some things I have to consider, plus all the written submissions on our meetings. So I'll take it to revise and I'll take a recess. Probably not less than 15 or so. decided to do it, I don't see a letter finding. It would be for 5 years. Part of my reasoning is, I know he has no prior, but it was a lot of money. And in reading what the victim impact statement submitted by the Boxborough, it kind of brought them nearly to the point of insolvency. They do a lot of good work in the community. Unfortunately, they work virtually unable to do anything because of the loss that they suffered. And this was conduct that occurred over the course of 3 years. It wasn't, as I said, a one-time thing. There was some deliberation involved, so I think that 5-year administrative probation, because he's almost on the has a condition of 500 hours of service, which roughly will turn out to be about 100 hours per year. And no contact with the Boxborough organization members. It would be a $90 victim witness fee. If he's willing to accept that, that's what it will be. I think that he's, and I think he will, some of the life I trust will be successful on probation because of his, I appreciate his resourcefulness and the fact that he took measures very quickly to pay back the installment.
Thank you, Your Honor. He accepts.
You accept that? Okay, so I have some questions for you. I want to make sure that your admission is voluntary and you're aware of the consequences. You heard the fact that we read about the prosecutor earlier. You said that was the fair distribution of the car. Is that right? Yes, sir. Have you had any drugs or alcohol or medication in the past 24 hours? Is there any history of mental illness that appears today?
No, yes.
And your age, sir, was 53. Is that correct? And you're presently working for a high-tech company?
Yes, sir.
Employed full-time?
Yes, sir.
Okay. And you have a college degree?
Yes, sir.
Are you giving up your right to have a trial before the jury or before a judge? Jury trial before the secretary, the lawyer, picking out the jury from the Middlesex County residents who come to this courthouse for the jury. The jurors are impaneled and sworn. They hear the evidence against you, and they must reach a verdict as to whether you are guilty or not guilty. The verdict must be unanimous. Do you understand that, sir? You can give up your jury trial right, and you can have what's called a bench trial or a jury waive trial. It's where a judge alone hears the evidence and decides whether you are guilty or not guilty. You understand that? Whether your trial is in front of a jury or a judge, you do have certain constitutional rights to give up when you admit to an offense. So giving up your presumption of innocence, that means you're presumed innocent of this offense. There's 2 offenses unless and until the prosecutor proves you guilty beyond a reasonable doubt. You're also giving up your right to confront your accusers in court through cross-examination by a lawyer.
Okay, as to this matter, counts 1 and 2 both stand continued without a finding until August 25th, 2015. There's a $90 victim witness fee and a $50 per month probation supervision fee. In addition, you're to perform 500 hours of community service, and you're to have no contact with the victims. And can you make payment of the $90 today, or do you need some time, sir?
Can I have a week?
Yes.
So you have until September 1st for payment of the victim witness fees. Please check into the probation department of the cashier's office.
Thank you very much.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you, ma'am.